So, what is it like going to a settlement conference in workers' compensation? My name is Kaplan Morrell. I'm an attorney here with Kaplan Morrell, and we help injured workers who have been injured, disabled on the job here in Colorado, and we have been doing this for 25 years, 20 plus years as a firm, and this is what we do. So we don't do divorces or wills or trusts or criminal law. We just help people with on-the-job injuries, and so this is our area if you want to talk about it. Oftentimes, we're going to go to a settlement conference in a workers' compensation case, and a lot of people get a little worried, nervous about it, and I want you to watch this video so that you can understand what to expect if your case goes to a settlement conference. Now, not all work injuries in Colorado go to a settlement conference. Oftentimes, what happens is you may settle informally with the adjuster. In other words, the adjuster contacts you, your attorney, and says, hey, and maybe you start trading numbers and that way. And that's certainly one way to settle your case. But the other way that you can settle your case is you can go to a settlement conference. And that can be intimidating because you're going to hear there's a judge. There's a judge. And you may worry that you may have to present evidence, you may have to testify. That's not the way it is. The judge in the settlement conference is what's called a pre-hearing judge, and that person typically has a lot of experience in dealing with work injuries. Maybe they were an attorney for the insurance company for many years, maybe they were an attorney for injured workers for many years. In some cases, maybe they were a judge that listened to workers' compensation hearings and gave orders. But in general, they're going to have a lot of experience with work injuries in Colorado. So the first thing that happens is you set a settlement conference, and everybody knows what day it is. And oftentimes, before you go to that settlement conference, it's good to at least have an opening offer. So that way, the insurance company has an offer from you, and that way, the ball is in their court, so to speak. On the day of the settlement conference, you can participate by phone. It could be in person. Certainly before COVID, it was in person, or it can be in terms of a video conference. We'll be doing a lot of those now. Once it starts, everyone is together, okay? Again, you as the client, as the injured worker, you don't have to worry because you have done something smart. You have hired someone like me who knows the system, knows what benefits you might get, knows what it takes to prove getting those benefits, knows how to value those benefits, and can anticipate the arguments from the insurance company when they say, no, you won't get that much. So the judge starts off the conference, and a lot of times the judge will do a opening introduction, and he or she is going to say to you kind of what the experience is, and that it's a voluntary process, and that if you don't settle your case, you're going to go to court, and then maybe a judge will then decide it for you, and you may not like that, and so this is your chance to reach a settlement where you get to control to some degree the number that you walk out the door with, okay? The judge is going to ask the attorneys for an explanation of what's going on in the case, what are the issues, what's happened in the past, what could happen in the future, because when we talk about settlement and workers' compensation, and we're going to have another video about this because settlements and workers' compensation are completely different than settling, for example, a car accident. But the judge is going to be interested in what going forward is the potential future things that might happen, because that's what's going to drive the settlement. When you settle your workers' compensation claim, you are only really settling what might happen in the future, because everything that's happened in the past, you've already received, particularly if it was an admitted claim. You've already received the medical care. Maybe you've already received the lost wage benefits. Maybe you've already received the impairment rating, okay? And so the judge wants to know that. So both sides kind of give a bit of a story. It tends not to be very aggressive. It tends not to be very argumentative. There's certainly nothing that you as an injured worker have to say, but maybe you might be called upon to clarify some dates or what kinds of surgeries you had, etc. But in general, it's a very low-key thing. The judge is going to ask whether or not there's been prior settlement discussions, and if you're with us, hopefully we'll be able to say, yes, Your Honor, we've made this offer and we are waiting for the insurance company to respond. At that point, the judge is going to move us into different rooms, and that can either be physically, where we're one room and they're across the hall in another room. It could be virtually, where we're in one virtual room on the video conference and the other side is in another. And the judge is going to go to talk with the other insurance company. And that's the time for the insurance company to go, here's why we think the injured worker and his or her attorney are just mistaken and they're wrong and we don't think it's going to be as serious as they say. And they're basically going to do everything they can to just explain to the judge why your case isn't as great as you think it is and as your attorney thinks it is. And at that point, they're going to give what's called a counteroffer. And so, for example, I may say in a case, we're willing to settle for 75, and then the insurance company lawyer is going to talk with the judge and the judge and say to the judge, we'd be willing to offer 15, let's pretend. And the judge is going to say, okay, why do you think it's only worth 15? What are your talking points? What do you want me to share with the other side about your position? So meanwhile, my client and I are just kind of waiting in the other room. Maybe we're reading a book, maybe we're watching TV, and we will wait until the judge comes back. And it could be anywhere from 5 to 15, 20, 25 minutes, 30 minutes, depending on it. But eventually the judge is going to come back and the judge is going to say, well, their counteroffer is 15, and here's the big points that they wanted me to say to you. What's important for you to understand is the judge that is doing this doesn't have any power whatsoever to order you, the injured worker, to accept less than you want, but also the judge doesn't have any power to make the insurance company or offer you more than they want to do. All the judge is there to do is to kind of help people get closer and closer. Sometimes the judge will give his or her opinion, geez, this, I've seen these, and for, a scar that size, I think, the orders I am seeing, it's really only between $300 and $1,000, and you're thinking it's $2, but I don't think it is, etc. But that's just the judge's perspective, and the judge shares that with us in private, okay? Just as you need to understand, when the judge is with the insurance company, and the insurance company is saying, oh, we're going to win, blah, 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 the judge is also there going, yeah, this lady looks nice, and she comes across as very believable, and I've seen this, so there's going to be a lot of pushback from this judge on both sides, and that's kind of how it works. Anyway, we'll then listen, and then maybe we'll come down from 75 and we'll offer 65. And back and forth it goes, with the judge going back and forth from each side, spending, frankly, less and less time each time. And eventually, one of two things is going to happen, okay? Either we're going to reach a number that my client is willing to accept, the insurance company is willing to offer, and we've got a settlement. Great. Or my client's here, the insurance company is there, and we just can't get in an agreement on the middle. That's okay, because for two reasons. Number one is, maybe with some time we'll come back to it, and maybe there will be some movement. Or if we can't settle, then at least you can go to court knowing, I was here and they were there, and there was no way I was going to go there, and I'm going to go to court, and if I win, great, and if I lose, that sucks, but at least it was my decision. I heard their best offer, I thought it was bad, and I was willing to make the risk, okay? And I was willing to go to court and lose, rather than take their paltry, crappy offer, okay? And then the third thing that's also helpful in settlement conferences is if you can't reach a settlement, you at least get information from the other side. You at least get a preview of what they may argue against you. And that way, if you go to court, you know some of their arguments because they were telling the judge that to try to get you to accept a lower bid than maybe you were willing to do. But that's how it runs. Everything that you say in front of the judge is confidential unless you tell the judge otherwise. And the judge doesn't have any power to force you to take an offer you don't want to do. And it's a very common should be stress-free on your end, other than you're having to make an important decision. But the good news is you've got an attorney who knows the law and can recommend what areas are reasonable, what areas are not reasonable, and you can make an informed decision based on your risk tolerance. As always, work injuries are very complicated, and so if you or someone you know has been injured on the job in Colorado, tell them to come and contact us. Give us a call, 970-356-9898. We have been helping injured and disabled workers here in Colorado since 1997, and we would love to be able to help you or your loved ones. Have a great afternoon. Thanks for spending some time with me.